is going to be challenging on both sides. But as a not lawyerologist, I thought we'd get an actual lawyerologist. We would
Sure.
phone a friend.
Yeah, no worries. So it's this old thing called corpus delicti, which is show me the body. And the idea behind that is that you don't want people like confessing to unaliving somebody without any evidence of unaliving somebody. And so everyone has always had this misnomer that you need an actual body to convict somebody of this type of crime. But you don't, and you haven't for hundreds of years in all the 50 states that I'm aware of. Although I'm a Michigan attorney, I think it's fairly general across the board that you can use circumstantial evidence. Now, the prosecution has to prove a death, and then they also have to prove an unlawful death. So, so their hands are tied a little bit, in that trying to prove both of those things is difficult without a body, but it's not unheard of. So, they're going into blood stains and they're trying to say that this is enough blood to either one, there was a death, or two, it was due to, unlawful or unnatural means, right?
Yeah.
So the defense could attack that though and say, well, that blood is old, or that's not enough to cause a death, or yeah, she cut her hand once and that's why there's blood there that matches her. So there's attacks on both sides, and then there's other evidence that could be used. Credit card, bank statements. She hasn't used any money or bought anything in the last 2 years, but all of it revolves around circumstantial evidence. And is it a reasonable inference that this person is no longer alive based on all this evidence? And is it also reasonable inference that she died due to unlawful means? And then is it also reasonable inference through the circumstantial evidence that this guy actually caused the unaliving? So they have to
Yeah.
pile on so much evidence because they have to create the circumstantial
Well,
case.
yeah, I knew it would be different, but I didn't know the technicalities behind it. Now, I have a bonus law question. Now, there seems to be some squabbling because it looks like the state is wanting to bring in the fact that he pled guilty. It seems like they're wanting to put it in their closing statement from what I'm gathering by what they've been putting in. Now, the defense looks like they are not wanting that to happen, but it seems like the defense tried to do an end run and get him the lowest possible sentence for what he pled to by having him be sentenced at the start of trial. Because the defense was actually, so like day one before they even got opening statements, his defense attorney said, "We'd like to go ahead and sentence him. We're here for sentencing." And the judge was kind of okay with it for the first day and a half. And then she said, "I've thought about it. And because of the way the statute's written, basically, if she makes the wrong choice, she might have actually wrongly sentenced him if he's not convicted, because the longer end of the sentence is in connection with a life ending felony."
Yeah, see, I that's outside of my knowledge base because I don't practice in that state. But sentencing is generally governed almost entirely by statute these days. And
Well, that's what I thought. So I didn't figure there was a lot, but it did seem like they were trying to get it in so he could stay on the closer to 10 years bit of the penalty phase, which I thought was an interesting strategy.
well, it is. If there's, like we deal with a lot of, we call them firearm kickers, right? If you commit a felony and you commit a felony with a firearm, it's a the punishment is a lot stricter if you have the firearm when you're doing it. So we can try to plead to something and get rid of those kickers, as we call them, or those multipliers. And so that might have been their strategy with this, because if you're, hiding a corpse or whatever it was that he pled to, but you're doing it in order to conceal your other crimes, there's probably an added, sentencing range
Yeah,
involved. So that makes sense that they did that. And the judge was probably right to not sentence him until after this trial. I
MLS,
thought, was that?
this is a redux of the Chandler Halderson. I actually did dismembered defenses, the opening statements of the Chandler Halderson defense and then the Brian Walsh defense yesterday. And I was like, holy crap. We all thought it was dumb when Chandler was like, okay, maybe he dismembered him. Maybe he lied to cops, but he didn't murder them.
We had a similar case in Michigan here that I actually streamed, where a cousin, I think Salvador and I dual streamed it, where a cousin was accused of unaliving his female cousin and then hiding her body, and their defense was as well, she just up and died and he panicked and didn't know what to do and dumped the body. That was his defense. Now it didn't work, but it's a similar defense here. And when he first pled, when Brian first pled to the two counts and not all of them, my thought is that they are going to use this to try to exclude evidence from the murder trial that they otherwise would have gotten in because it's relevant to the two counts he pled to. And then Runkle turned me on to the idea that they're making it easier for Brian to testify. So I've now switched my position, and I feel all of this is trying to limit the scope of cross-examination when Brian actually testifies. So I think he's
I
going to
guess that's a
testify.
perspective I figured he was going to testify because that's what the opening statement alluded to. And I don't know how if you agree with this or not, but essentially this is kind of like a self-defense case where he has to go up and testify because he's basically banking on the jurors to say, okay, it's reasonable. Like, okay, maybe I wouldn't do this, but okay.
Yeah.
I mean, it kind of has to be like denting gum. 9 out of 10 dentists would dismember their wives if they came upon them dead.
Yeah, it's going to be a hard sell. And I don't think he is going to do it if I were a betting man. But
Hey,
if
I'm
it's the
here for
only
the
thing you
train
have,
wreck.
it's the only thing you have, right? So thinking about the Murdaugh case too, I don't think he unalived his wife and son. He had to try to convince a jury that he didn't. He got up on the stand, and I think he did such a bad job testifying. I still don't think he did it, but I understand why the jury convicted him because he
I
was
didn't
so
get
bad
into
at
that
testifying.
case because I heard that it was 6 weeks of finance, and I was like, numbers? No,
Yeah.
that'll be a no for me, dog.
Yeah. So, it's really risky to put your, you know, defendant on the stand as an attorney. But sometimes it's the only thing you have, and
Well,
that might be the
yeah,
only thing here. And he might be super convincing. I don't know. It's possible. I just
it,
don't buy it.
I don't, but I do want to thank you for popping in and, because I usually say, like, go look at real lawyers. Like, I'm okay with you leaving my chat and asking a real lawyer because I don't want to, you know, tell y'all something, blow smoke up your behinds. Y'all know I'm a twice college
Right.
dropout.
Well, just the main focus is it's entirely circumstantial, and the state has to prove one that there was a death, two that it was done through unnatural means, and unaliving, and then three that the defendant did it. And so when you have to prove all of those three factors based on circumstantial evidence, you just have to pile up the circumstantial evidence to the point where you're almost presenting a movie, like a thriller type movie, and you're like convincing the jury, who are just regular people, like, come on, use your common sense. This guy did it. She's dead. She was unalived. She didn't die naturally. And that's basically what they're trying to do. But they have to paint this entire picture. And unlike a movie where you can leave small little hints and
Yeah.
inferences, you've got to just methodically go through it very technically and present all the evidence. And so it's going to be a long, tedious trial. But I'm waiting for Brian to get on the stand. That's going to be interesting.
I am just waiting for Old Man River to come up with a cogent question just once. Just once. And then you do have a question. What do you think of Andrea Burkhart's position that she would put most of her clients on the stand? So,
So actually, I was talking about that with my Lego Law Life and Libation stream just on Saturday with Nick Ricada. Um,
woohoo! Plug, plug,
but
plug. Go look at it. Go check it out.
we were talking about that, and Steve Gosney has the same position. And I think it's interesting that most attorneys are going that way. It used to be you don't ever put your lying guilty client on the stand. And now it's almost you must, unless you absolutely can't for some other reason, put your
Well,
lying guilty client on the stand.
does that go to the unintentional reaction to the CSI Law and Order, all of the kind of fictionalized law
Yeah.
that now the burden has shifted to the defense to prove that you're not guilty, which is
It's like that, although I hope it's not to that extent, like you said. Like I hope jurors still walk in there knowing that the burden is on the state and the defense has to prove nothing. But
no,
it's
they
the
don't.
courts
As
are
a
always
four-person on a
yeah.
trial, they're like, okay, well, we just make sure that he's not guilty. I said, no, we would presume he's not guilty from the go. She's like, I don't think you know what you're doing.
So it's courts are always behind society, right? So when you had the OJ trial and this DNA evidence came out, all of a sudden everyone was like questioning all this science that the defense was presenting and be like, huh, why didn't the state do that? So then we moved into this what we called CSI effect, where the juries wanted to see the science and they wouldn't convict unless there was science and or video. And now we've moved into more of this video phrase where if it's not on video, it didn't happen. And we're also moving into what I have termed the CSI effect, or not CSI effect, the like the Dateline effect of where we want to sit back and hear this case and we want someone else to tell us why he's not guilty, right? You think of Making a Murderer
Oh, yeah.
as sort of, when everyone was on lockdown with the vid or no, that was before that. That was Tiger King. But before that, with Making a Murderer, everyone was like, oh, wow, they railroaded this guy. The defense should have proved this. The defense should have brought up this. And so we're now sort of, the courts are slowly turning again towards where society has been for quite a while, in that they want to hear from the defense. They want people to speak up for themselves. Tell us your truth. Be empowered. Don't not just be a victim of the state. Tell us your truth. So now we have to address that and be like, the jurors want to hear from people. They don't sit back and say, well, the state didn't prove. They want to know why. What's the defense's side?
The thought process. And I think that a lot of, as true crime is growing and as, podcasts and things, I think there is a very big disconnect and misunderstanding what can be said on a podcast versus what can be brought in a court of law. And we saw it in the Wolfenberger case very recently. And I believe there was a case in Arizona, Michael something or other. There are these cold cases that are coming up that have a big podcast following, but there are things that you can put on a podcast you can't bring in the court of law. And I think that's something that we're going to keep running into.
It definitely is. And that was part of what we were talking about with Nick Rekieta, was specifically with the Johnny Depp case, because the question was posed to him, what would you have done differently if you were Johnny's attorney? And he said, I would have been out in social media a lot more and talking a lot more instead of staying silent, because that's not the norm anymore. Staying silent and letting the process do its thing, and then letting the other side with the burden, establish their burden, is not a thing anymore. That's just not where society is. And juries are made up of members of society. So you have to meet them at their level. And so that's the biggest thing. And so that's why I know the Lorax, he used to say the same as me. I always said that, you never put your client on the stand unless you absolutely have to, but times are a changing and you kind of got to default to that unless there's a really good reason not to.
Yeah. Well, thank you so much for taking time out to answer my questions, because, I am naturally blonde under this.
Yeah, which I just learned today, which was interesting. I didn't know you were artificial ginger.
I know.
That's a
I call it my
choice you
artificial.
made.
Honestly, I was going to go brown, but the first time I dyed my hair, it went really red, and it really irritated my mom. And, what better reason is there to do anything?
Right. Well, I'll be hanging out in chat, listening away as I'm
Alrighty.
doing my other stuff.
Sounds fun. Thank you so much
No
for
problem.
answering the lawyer signal, and I will see you later.
All right. Take
And
care.
check out the Lego stream. It's 3 L's and it's escaping
Lego
me at
Law,
the moment.
Life, and Libations.
I was like Legos Lawlessness and Lucy Lawless. I was like,
It'll
that
get you
none of
there.
those
Yeah,
are right.
that'll get you there too.
Bye. Alrighty, let's get back. And thank you guys for, allowing me to do that. But I really, do like giving you guys correct information. If I don't know something, I'm glad.